Okay, good afternoon, ladies and gentlemen. Welcome to this Law Tech Talk hosted by the Law and Technology Center of the University of Hong Kong. I'm the chair of this talk, Felix Chen, and our distinguished speaker today is Dr. Xiaowei Yu. Dr. Yu is a postdoctoral fellow at the Law and Technology Center of the University of Hong Kong. Dr. Yu earned her LLM and also her Doctor of the Science of Law, JSD, from the University of Illinois. She also received her master's degree of jurisprudence and her Bachelor of Law from China University of Political Science and Law. Without further ado, I would like to invite Dr. Yu to deliver her talk on the identifiability problem in transnational privacy regulations. So thank you, Dr. Yu.
Thank you, Professor Chen. Good afternoon, everyone. Welcome to this Law Tech Talk. In today's talk, I will focus on the identifiability problem in transnational privacy regulations. The major content of this talk comes from my JSD dissertation and a co-authored paper about informed consent in pseudo-contract. If you have any questions and comments during the talk, please feel free to type them in the Q&A box. Thank you. Imagine a normal day in 1980. In the middle of the day, you just walk around and stop at a bookstore and flip some romance novels. It is your secret guilty pleasure for a long time. You feel safe reading those books in the bookstore because no one else is looking at you during the noon time. And then you go to a pharmacy and buy some cough drops and a contraceptive quickly. After that, you participate into a LGBT conference and meet new people there. During this day, some people like shop assistants in the bookstores, pharmacists, other consumers and conference participants may observe you and notice some facts about you. Your gender, your height, the color of your hair, and they may even have inferred some aspects of your health. Possibly you got a cold, or your sexual activity, possibly active, or your sexual orientation, maybe LGBT. But most information may be forgotten very, very quickly, and very few people have the motivation to exchange information about you. Today, things could look very, very different. Instead of going to the public place, you can do all of those things at your home. You can read the same novel through Amazon, order cough drops on CVS, and purchase contraceptives on Target, and attend an LGBT conference over Zoom. The whole set of affairs make you feel more private, as it happens all at your home. At the same time, your email starts to receive many Amazon's recommendation on the similar types of romance novels. You are also required by the public health authority to do a COVID test due to your frequency of buying cough drops on CVS. And your mailbox is full of Target's advertisement for contraceptives. Facebook immediately identifies the particular person you just met over Zoom and suggests you to follow her. Even Google knows something about you because Chrome is your default browser. Compare those two scenarios. We can see that tracking technology engage in our daily lives in a more extensive and penetrating way. We are aware of this profound change, but we are less experienced it as problematic. Besides, we feel more private, but it is deceiving. Company is collecting and processing information about us. Much of those information is permanently stored in digital forms so that computers can piece all the information together to gain a more complete picture of us. Companies, including those that own the websites but not limited to them, are increasingly motivated by monetary reasons to exchange information about us with many third parties. This is all possible because of the commercial uses of tracking technologies. I call it cuts. The FTC in this summer named a similar phenomenon as commercial surveillance, and FTC defined it as the business of collecting, analyzing, and profiting from information about people. There are three types of cuts that catch my eyes. So first, cookies. I'm not talking about Halloween cookies, but cookies are small text files that websites sends to users' browsers and store in their computers temporarily or permanently. Cookies are used to keep information about users' visits. By using cookies, users enjoy the necessary operation of websites. At the same time, allow websites to track their online activities. And the second type is smart device. A smart device is an electronic device that connects to the internet and other devices for data exchange. Based on the interconnectivity, smart devices can fulfill multiple tasks. For example, Alexa, a digital assistant from Amazon, can notify upcoming schedules, deliver messages, update sporting events, evaluate health status, control home devices, order food, stream live music, hold conference meetings, and answer questions and more. It is even hard for me to speak out all the functions of Alexa. By having Alexa at home, users enjoy innovative functions, but at the same time, users allow Amazon to know their private activity, private conversation at their home. And the third type of cut is algorithms. Algorithms are a set of mathematical formulas that no one can fully understand. Unlike cookies and smart devices, algorithms do not directly collect information about people, but work behind the scene to process various types of data, interpret the meaning of data, and find out patterns or behaviors. Algorithms are brains of tracking that enable the operation of personalized recommendations, offers, and ads, and more innovative functions. Nowadays, if a consumer is completely tired of being tracked by cuts or by Facebook, for example, and he or she wants to sue Facebook for privacy violation, this person must prove his or her data are identifiable. In other words, this data can exclusively identify him or her. Otherwise, no violation of privacy legally occurs. Therefore, when data are identifiable is the key for consumers to sue for damages. The standard of identifiability decides when data are identifiable. So identifiability becomes my focus point. When I start my project, I noticed that cuts or commercial surveillance cause the same privacy concern everywhere. It is not a unique industry in the United States, China, or the EU, but a core industry of digital economy on a global scale. Besides, facing the global privacy concern in cuts, many jurisdictions seem to coincide on using identifiability as a critical gatekeeper and encounter difficulties in its application. I have an intuition that there is a huge commonality in use identifiability. But privacy literature provides little comparative insight on legal discourses over identifiability. Scholars discuss identifiability mainly limited to one jurisdiction. But at the same time, the comparative perspective is widely used and recognized in the field of data privacy, except identifiability. Due to those reasons, my research question is how similar or different in the legal discourse over identifiability in different jurisdictions. I choose EU, US, and China mainly based upon my language capabilities and my legal trainings. At the same time, EU and the US are well-established models of data privacy in the literature, while China is rarely discussed. So I think it will be an interesting study if I put all of them together. And my methodology is quite interdisciplinary. I use doctrinal analysis to understand how each state define and apply identifiability. And I also use comparative analysis to compare and contrast different legal discourses. At the end, I use a normative analysis to inquiry the normative foundation of identifiability. That is why identifiability matters to data privacy. Due to the time limitation, I won't be able to present all the details of my analysis in this talk. Instead, I will only highlight some key points in the later presentation. So let's turn to EU first. The EU legal discourse over identifiability derives from the concept of personal data in data protection laws. In the EU, the default rule is companies are not allowed to process personal data unless they comply with certain legal requirements, whereas they are free to use non-personal data. For this reason, determination on the legal status of data, personal or not, is really important. And identifiability is a crucial standard to decide the scope of personal data. The GDPR defines personal data as any information relating to an identified or identifiable natural person. I use different colors to distinguish elements in a definition. I will use the same color coding in each legal text so that everyone knows how many elements in one definition. So under the GDPR, if we want to decide what constitutes personal data, we need to ask 4 questions. What is information? What is relating to? What is identified or identifiable? What is a natural person? The standard of identifiability mainly refers to the third question. What is identified or identifiable? So in the later part of this definition, GDPR gives an explanation on what is an identifiable person. It says an identifiable person is one who can be identified directly or indirectly, in particular by reference to an identifier. There are 3 points I think is important. First, it is can be identified. That means the person is not yet identified, but there is a possibility that this person will be identified in the near future. And the second point is directly or indirectly. That means a piece of data or a combination of data can make a person identifiable. That will make this test fulfilled. And third point is GDPR emphasizes some identifiers has a strong capability of making a person identified. However, when you read the text, it's still a little bit difficult to decide when a person can be identified. In order to better determine whether a person is identified, GDPR introduced another test It's called the reasonable likelihood test. And there are also 3 points I think important in this test. So first, this test only cares about the objective possibility of identification. That means companies' subjective intention do not matter. If a company has no intention to distinguish a person from others, they are still liable as long as there is a possibility of identification. And second, GDPR emphasized this test is contextual. So one piece of data can be regarded as personal in one case and regarded as non-personal in another case at the same time. So the legal status of data is quite unstable. It is all based upon the contextual factors in one specific case. And third element I think is really interesting. GDPR emphasized that anyone, as long as anyone on the earth, not only data controllers, but anyone living on the earth has the capability of making a person identifiable in one specific case, that company is liable. So for example, company A has no capability of identify a person in one case. But company B, there has no relationship between A and B, but company B accidentally has the capability to identify a person in the same situation. And then company A is liable for that. So due to those this very broad approach, a legal scholar named Portua calls the GDPR the law of everything. Because the scope of personal data in the EU is very, very broad, almost every data can reasonably be argued as personal data and deserve legal protections. So to sum up, the EU legal discourse over identifiability is very consistent, and they only have one approach, which is a little bit uncertain, but also at the same time extremely broad. And the second jurisdiction, US. So the United States legal discourse over identifiability mainly comes from the notion of personally identifiable information or personal information in informational privacy statutes. In the US, the default rule is consumer data are free to be processed by companies unless there is a law to address market failures. Based upon this philosophy, PII or PI is based upon protecting consumer interests. In 2018, California passed the CCPA, which challenged this default rule a little bit. And it established a right approach like the EU style, which means California residents are empowered with a set of digital rights to manage their personal information. In the US, determination on the legal status of data is still important, and identifiability is a crucial standard to decide the scope of PII and PI. Unlike the EU, the United States have different approaches to identifiability. There are at least 4 approaches, and the previous 3 are developed by Schwartz and Soloff in 2011. And the 4th one comes from the CCPA. So let's check each approach. So the first one is a tautological approach. The VPPA adopts a tautological approach and it defines PII as information which identifies a person as having requested or obtained specific video materials or services from a videotape service provider. When we read this text, it seems a little bit weird because the legislators put more efforts on defining what a person is under VPPA. So this is because in the United States, data privacy law regulations are sector-based. Only when a sector or industry has a law to address privacy concerns in the industry. Otherwise, there is no law to govern the privacy issues. data privacy issues. So legislators must be very careful about delimiting the industry. That's why the VPPA only protects consumers in the videotape service industry, and it does not cover other consumers' interests. And compare with the person, other two elements, information and identifies, are lack more explanation and definition in this statute. If you check the case law about VPPA, judges struggles about how to interpret identifies. For example, whether IP addresses can identify a person under VPPA is quite debatable. Some people think yes, some people say no. And our debate issue is what it means by identify. And the second approach is called the non-public approach. The GLBA adopt this approach and defines PII as non-public information that is provided by a consumer to a financial institution, resulting from any transaction with the consumer or any service performed for the consumer, or otherwise obtained by the financial institution. So similar to the previous one, legislators put more efforts on where the information comes from, the industry, what the industry is, but they less care about what it means, personally identifiable information. And when I first read this text, I have two questions. Does PII means data that is non-public? Or does it mean PII means data from specific sources? But both questions are not answered in the statutes. And there's no definition on when or what constitutes personally identifiable data. The FTC give a list of examples of PII or NPI under GLBA. In the list, you don't see IP addresses or other data that is treated as personal in the EU, but more like financial data are emphasized in FTC's list. And third approach is called specific types. The COPPA use this approach and define PII as a finite list of data. So there's no definition of PII, but just give a list of data that automatically as or inherently as PII in all situations. For example, COPPA use names, treat names, physical addresses, social security numbers, phone numbers, and email addresses as PII. In 2000, FTC expanded this list to persistent identifiers, such as cookies and IP addresses. The advantage of this approach is it increased certainty to apply identifiability, but it leads to a very restrictive and a narrow scope of personally identifiable information for legal protection. And the fourth one is called broad approach. The CCPA defines personal information as information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked, directly or indirectly, with a particular consumer or household. It looks fancy because you will see the CCPA gives more words to describe what is identify or what is the word that is similar to identify. However, CCPA doesn't define what's the meaning of each element. Besides, CCPA also expands the scope of data subjects from a particular person to a household. Unfortunately, it doesn't define what it means a household and when a household is identified. And in a public comment, some public comment says they want to ask whether the IP addresses are personal information under CCPA. And the AG of California refused to say yes or no. And their response, it is a case-by-case study. So they think IP addresses are possibly be considered as personal information, but whether it is PI, it depends on the case study. So if we think about all the approaches together, we will see in the United States, there are diverse approaches to identifiability, but they share some commonalities. So first, identifiability is still an important and critical standard to decide PII and PI. And its application generally lacks certainty. Like some of them lacks definitions, some of them use contextual analysis. Both of those reasons increase uncertainty. And its application is either too narrow or too broad. So it's really hard for judges and regulators to apply. So the last jurisdiction is China. China's legal discourse over identifiability comes from the concept of personal information in security laws, civil code, personal information protection laws. So in China, the default rule is very like the EU one. So personal information is not allowed to process unless legal obligations of companies are fulfilled. Unlike the EU, China's protecting personal information in China is motivated by the security interest. And also personal information protection is not a human right, but a legitimate interest in China. In China, determination on the legal status of data is also very important, and the identifiability is a crucial standard to decide the scope of PI. And we will see there are three kinds of definition of PI in China. So the first one is a three elements definition. For example, the cybersecurity law defines personal information as various information that recorded electronically or through other means that taken along together with other information identify a natural person's identity. The civil code follows the same structure. It defines personal information as the information recorded electronically or in other ways that can be used by itself or in combination with other information to identify a natural person. In both laws, they don't define what identify means exactly. And in 2021, the Personal Information Protection Law gives a new structure of definition of personal information, which is various information related to an identified or identifiable natural person. It looks very similar to the EU style, but it doesn't define any of the elements in the definition, so it remains vague in the legislative level. In order to help regulators to feasibly apply identifiability and to determine what it means in personal information in China, China's regulators release several specifications. In 2020, they released a new version of the specification, and this specification is non-mandatory. So it's not like previous laws that they are binding automatically. It's just some standards that are proposed by some authorities. However, if relevant authority decides to use it in their judgments, this specification opinion becomes binding. So you have to be careful about when it is binding or it is not. So this specification defines personal information as any information that is recorded electronically or otherwise that can be used alone or in combination with other information to identify a natural person. This looks similar to the three element structure, but then it adds another several words or reflect the activity of a natural person. The specification calls the previous one, information identify a natural person, as the standard of identification, in which it means information that could help one identify a specific natural person through the specificity of the information. That information is personal information. which we see so many familiar words, but still there's no definition of identity. And the second standard, it is called the standard of association. And it means the information generated in the activities of a known natural person, such as the person's location information, call logs, and the browsing history, is personal information. For example, if you have so many information on your phone, you don't need to prove those information are identifiable or has an exclusive link to your personal identity. They are generated from your phone, from your activity of using your phone. So they are considered as personal information based upon this standard of association. In the judicial system, the Beijing Internet Court already apply those two standards from the specification 2020 in cases. So the court holds that WeChat friend lists and WeChat reading information, names, phone numbers, social relationship, and geolocations are personal information. However, the court says it is a case-by-case study. Even though they think in those specific cases, those information are personal, but this does not mean the same piece of information are personal in other cases. So other courts still needs to apply a case-by-case study. So in China, we can see that there exist multiple approaches, but identify is the key element to apply, but lacks further definition. And its application lacks certainty. For example, whether IP addresses are personal is quite debatable in China. And its application is broad. In the specification, it lists metadata to be considered as personal information, which is very unexpected to the EU and the US regulators. So if we combine all the information, all the doctrinal analysis we have previously, and we know that US, EU, US, China are quite different legal system, quite different legal cultures, and they even have different data privacy regulations. But there is a huge convergence in how they define and apply identifiability. So first, identifiability is the critical threshold to decide the scope of data privacy regulations across those jurisdictions. And second, its application is very uncertain. Some of the reason is some approaches lacks feasible definition and interpretation, and some approaches emphasize it is a contextual analysis. And third, its application is either too narrow or too broad. There is a hidden conceptual challenge underneath this too narrow or too broad situation. That is, identifiability is applied both as a binary categories and as a notion of degree. So when regulators want to decide a piece of data is identifiable or not, is a binary categories, we have to decide it's one or two. But as a degree, the degree of notion, the degree of identification is inconsistent with these binary categories. Therefore, it's quite difficult for anyone in all three jurisdictions to find an appropriate and right way to decide whether a data or a combination of data is identifiable or not. So based upon this huge convergence, I see how those stuff happens, and I define the identifiability problem as shared struggles against the uncertainty over identifiability across jurisdictions. There are 2 points to be clarified. First, this generalization is based upon 3 critical jurisdictions, so my intention is not to cover all jurisdictions. However, such a generalization transcends legal system, legal cultures, and data privacy philosophy, regulations, regulators, and a specific mechanism. And I see more and more evidence to fit more jurisdictions into this problem. And second, this generalization is based upon similarity in difference, which I mean those similarities are quite relative. It's not absolute similarity. It is questionable whether we can really find an absolute similarity between different things. But my point is, my focus is on the similarity parts. And it is very important and significant to see the existence of the identifiability problem in different jurisdictions. So first, it reveals an overlooked common phenomenon across jurisdictions. This does not mean that no one else ever noticed this commonality. My point is, this is the first study to take identifiability serious from a comparative perspective. As I mentioned before, in the field of data privacy studies, comparative perspective is very widely used. But most of the focus is on data privacy rights, data privacy obligations, and other provisions. However, as the key gatekeeper to data privacy, identifiability seems to be overlooked by comparatists for a long time and for no reasons. So my study is the first to reveal that it is an important and overlooked common phenomenon across jurisdiction. And second, it is a factual foundation of synthesizing transnational efforts to solve the identifiability problem. So even some solutions are proposed within a specific jurisdiction, other states can learn from them from a doctrinal perspective. Traditionally, doctrinal analyses are limited to one given jurisdiction, but recognizing the identifiability problem exists in different jurisdictions. It is okay, and it is a foundation for scholars to borrow, to learn from other countries' solutions. And the third one, I think is the most important one, is realizing the identifiability problem leads us to a normative inquiry, which I think is a deeper question. Why identifiability matters to data privacy? So when we see all three jurisdictions, we see there is a common intuition among those jurisdictions that identifiability really matters to data privacy. We feel like it's right to use it, and we think it's important to use it, even though it is so difficult, it's so hard to apply for regulators, but it should be the gatekeeper. But no one ever asks why we must use it as a threshold to safeguard data privacy issues. So I think if we keep thinking about this normative inquiry, we need to think more about why we care about data privacy. We can have different opinions in different countries, but at least someone needs to answer why it is important and why so many jurisdictions want to use it without clarifying the reasons to use it. And this is all my presentation, and thanks for your attention. Questions and comments are really welcome. Thank you.
Yes, thank you, Dr. Yu. And I would like to invite the participants to submit your questions by using the Q&A box.
Okay.
And Dr. Yu will respond to each and every question submitted by you. And I can see that there are already 2 questions in the box, and more questions are coming. So I would like to invite Dr. Yu to respond. Thank you.
Thank you so much. I will read the questions first. So the first question is, does big data technology further complicate the identifiability problem, as de-identified data may be re-identified more easily? And I think yes, my answer is yes. And in my study, re-identification technology is an important challenge on applying identifiability due to our time limitation, so I don't elaborate it in this talk. So thanks for your question. And the second one is, where do Hong Kong privacy ordinances stand today in terms of identifiability? How are they going to evolve in coming years in relationship to GDPR, China privacy protection developments? So thanks for your question. And I really want to know how the Hong Kong privacy ordinance define and apply identifiability, because I am a newcomer to Hong Kong. I just come to Hong Kong this August, so I'm quite new here. But if anyone has a better answer to this, feel free to type. And how accepting our course of de-identification or normalization technology as mature working solutions? And I think I like the second question because de-identification is another theme in my JSD dissertation. And since my first part is talk about identifiability problem and I leads it to a normative inquiry, my answer to the de-identification is, I think the technological understanding of de-identification is not enough. We need to have a normative understanding of what it means by identification. But that's a huge project, and it's a very complicated reasons behind that. So if people are more interested in that question, you can email me and we can have more conversations on that. And what do you think about IP location information? Is it PI under Chinese law? Thanks for your question. And IP addresses, it's a little bit tricky. I think in the EU it's quite clear that IP addresses are considered as personal data in many cases. In China, if we see the specification 2020, its IP addresses are listed as personal information. But I thought when courts really apply it, they may say it is a contextual analyze. So I don't have a yes or no answer to whether IP under Chinese law is. It really depends on how the court decides the case. And another question is about, as the concept of privacy itself has diverse meaning, is it necessary for us to have a unified definition of identifiability? Thank you, Simon. And I think, like, if you have an interest in privacy, when you dig into the privacy literature, like how scholars, how philosophers, how legal scholars define privacy, you will find that there are diverging definition, diverging conception around it. And it's really hard to have a unified definition, and which is unified and also is convincing to all of the people. Personally, I stand for a clustered definition of privacy. So that means there are different kinds of definition of privacy, but they are related to each other. So we don't need to find a unified one element to define privacy. We can have it a diverse interpretation in different situations. And is it necessary for us to have a unified definition of identifiability? I think I won't use necessary, because the current situation is different jurisdictions already use a very similar, even say the same way to define identifiability. So I'm interested if anyone else can propose a new way of defining it. And I'm really interested to read those scholarships. And I see another question is about, besides identifiability, do the three jurisdictions you just mentioned have any alternatives, other standards for the assessment and the protection of personal information? And yes, even though in when you see what constitutes personal data in the EU, what constitutes a PII in the US, and the personal information in China, you will see identifiability is only one of the standards that decides the concept. You also need to answer what is information, what is the relationship between the information and data subjects, and what is the scope of data subjects. So identifiability is important, but it is not the sole standard. And also, if you talks about assessment and the protection of personal information, I think there are more mechanisms like the informed consent, which is my another research interest. Is an important proxy to talk about the a situation or protection of personal information in all three jurisdictions. So I think, yes, there are more standards than that. The next question is that identifiability is also relevant to the standards in the cyberspace. My question is there any agency authority in EU, California, like the function as in PRC? So I think the standardization law authorities in China is very unique. If I'm wrong, please correct me, anyone. I don't see the EU or California has similar agency like the standardization law committee in China. But like the function, I see many agencies, they propose ethical standards, but that's very non-ethical and that's not mandatory for bounding. So if anyone else knows the answer, please type your answer in the box. Thank you. In your opinion, should we have another threshold test to protect data's privacy? For instance, should our focus be on risk or harm against individuals? Should we regulate on data combination and re-identification? And I think when I first think about the threshold issue, I'm thinking about to develop the threshold from the perspective of risk harm, which is traditional way in the United States scholarship. Like legal scholarship in the US always try to develop some framework based upon risk and harm. But after I dive into this field, I found it's not easy to define what is risk and privacy harm. Even Solomon has a paper about privacy harms, and he developed a typology of privacy harms. But still, for me, I think it's still a vague and still not so reliable, not so clearly cut threshold compared with identifiability. So I think what we want to do now is we really want to protect the data privacy. So what is the value that we think is so important in our society, in our age, that we cannot compromise by companies? So for me, I think if we have clear answer on that, it could be a replacement to think about identifiability. Yeah. And the next question is about any way to make PI not identifiable so that personal data laws will not be applicable. So I think it's a very technical issue. I'm not a tech guy, but based on my research, for what I'm looking for based upon my research interest, I see more and more scholars think de-identification and normalization, including the encryption, plays limited function to prevent personal information to become identifiable. So that's a very brave answer. Yeah. how could identifiability fit into a privacy by design approach? Thanks for your question. And privacy by design, based on my understanding, is very technological approach. Like you use codes or use technological ways to build models to solve the privacy issue. Like Helen Nissenbaum's contextual integrity is welcomed by privacy by design scholars. They use her contextual integrity framework to build mathematical models to decide when privacy issue happens. But in that model, identifiability is not a factor. So I think it could, but how we use it in a mathematical way or engineer way, I think we have to define first what is identifiability in a normative way. Like, I still think it's not only about technological stuff. It's still about normative. It's still a normative issue. That if we are not clear about what we are protecting, we just cannot apply identifiability in an appropriate way. In your opinion, what is the advantage of identifiability over other standards in terms of regulating personal information? So first, I am a little bit confused what is about other standards, but I think the advantage of identifiability is it fits our intuition. We just feel it right. So I asked so many people, like, how do you feel about standard? Everyone says it is right. No, why? You have a problem with it. So I think even though so many scholars already propose different approach to replace identifiability, if you see how the law is legislated, people just use identifiability for no reason, and they don't care about other frameworks. So I think it's the advantage I'm thinking about, and also it's quite easy easy to apply in the sense of regulators just have to make a decision, identifiable or not, and then the material scope of privacy regulation is decided. So the next question is how to understand the relationship between personal information and the data and the PRC law. Okay, and I do see many scholars talk about information is different from data, and also when China used personal information rather than personal data as a fundamental concept, many scholars want to find out the differences between information and data, and I see some mature scholarship in this field. But for me, I don't have my personal view on that. I just think data and information, in terms of my study, it's almost the same, and I don't see how the difference influence my study, but it could influence other studies. Okay, the last question is, does identifiability really matters to data protection? Should we pay attention to group privacy rather than personal privacy? Because there are much information couldn't identify a person, which still deserve to protect. And there is several Europe scholars, they propose group privacy theory. And in their proposal, they think identifiability applied to individual level is outdated. So they already propose that we should target identification of a group of people rather than a natural person. But in terms of that, I think they do not replace identifiability. They just revise the meaning of identifiability from individual level to a group level. So if you are interested in that, you can see how those scholars from Europe, how they discuss your concern at a group level. And I think that's all the questions I have received now. And thanks for your questions. I really enjoy talking with you guys.
Thank you, Dr. Yu, for your excellent presentation and your insightful responses to the questions raised by the participants. And I would also like to thank the participants for the very active, engaging participation in this talk. And for the upcoming events and Law Tech Talks, please pay attention to our announcements on our website from the Law and Technology Center of the University of Hong Kong. Okay, thank you very much. See you soon in the next event. Thank you.